Okay, so we back in the building for a third day in a row, coming with the law. All right, we're gonna keep this thing going. Like I said, every day. We're gonna be every single day. We're gonna put some good time in. I don't know, probably be about a good 30, 45 minutes today. But we got some real good topics, some real good things to chop it up about. And again, remember, I'm keeping all of this in perspective. Um, Everything is going in order with the manual that I will be reading and teaching from. All right. So, this next topic that we're going to read about is about the business deal. It's about the business deal, people. So, generally speaking, okay, co owners of a business, they're entitled to make whatever business deal between themselves that they choose. All right, that's a beautiful thing. It's a given, actually. To the extent they do, they typically express their agreement in the entity's fundamental documents. Back to that word, fundamental documents again, basically referring to the articles of organization or the operating agreement, depending on which legal structure that you currently have. Okay. So, to the extent they do not make an agreement, express or implied, the law implies the agreement contained in the entity statute for the type of entity created. So, basically, whatever state you're in, if you don't have an operating agreement, you basically have to go by what the statutes of that state says. All right. So, whether expressly or impliedly, the agreement addresses four basic issues. Okay. How the investors and managers will make decisions. And keep in mind, when we say investors, when we say managers, it makes it seem as if these things you have to have plural or multiple members, but you do not. One single person can be the investor, the manager, like I mentioned in the previous videos, the secretary, the CEO, the cook, all of those things legally. All right. So, whether expressly or impliedly, the agreement addresses four basic issues: how the investors and managers will make decisions, what fiduciary duties the investors or managers will have, what resources the investors will contribute, and what they will receive in return. Also, the transferability of the investor shares. And again, all of these things your LLCs are privy to if you activate your LLC. And what I mean by that is setting your LLC up where it's paying its own taxes. The only two taxpayers here in the United States of America is the C corporation and the individual. As I mentioned, 85 to 90% of people have their LLCs are operating their LLCs in the default status, and they are not operating them in the status where if they want generational wealth, if they want to create a business that's totally separate from themselves, that's its own taxpayer, if they want to have limited liability. If you, just because the name of it is a limited liability company doesn't mean that you have limited liability. There's certain things you have to do, certain steps you have to take, which is why um, I'm here for educational purposes. We're going to learn those things. It just depends on how it go. You know, these things take time, this knowledge, the information, the research, being able to put it out to you guys. And we're gonna see how supportive, people will be. But I'm gonna continue to do it on a daily basis. But when it comes down to certain pertinent things, you're gonna have to have somebody hands on. So, it's only fair that, you guys reach out, inbox, um, call, text, set up times to chop it up and get some things done. um I'm gonna put the information out there. Of course, I'm gonna put the information out there, but just respect the game. We can't cheat the system. Just know that, people. You can't cheat it. You can't. You can, sit up and soak up all the information you want to soak up, but then when you go run, go do something, and you run, go try something, and you don't have all of the in and out of everything that you need to do. You don't actually have that experience. It's gonna be just like not really having the information. Don't be a information thief. Then go off on your own and you get things. I'm gonna give you the game. I'm gonna give you the information. We can share it together. You know what I mean? And we can go through some things. We can set up some times, and we can walk through some things. I can coach you through some things, and we can discuss the fees and all of that, which would be reasonable, but it's going to be worth it because you can't cheat the system. You try to cheat it, get the information, go run off and do something, you're still going to be stuck in at a standstill, feeling lost. So then you lose twice. You know what I mean? But let me keep going. All right, so we're gonna talk about the decision making. It's just different types of decision makings that, as an LLC, as the owner of an LLC, I don't really like to use the owner because you really don't own it. You know what I mean? Once you dive deep into this whole thing, you will know. I know you guys may have heard Warren Buffett say, "Own nothing but control everything." And you literally do not own it. The only thing you own are shares in the company. You don't own the LLC, but you own the controlling shares. You can manage it, you can work for it, all of those things, but you really don't own it. But your LLC does own your business. You don't even own your business. Your LLC owns the business. But anyway, let me keep going. All right, so basically, entities, and when I say entities, I mean LLCs, but the LLC has to be activated. You have to elect the C corporation status. This is where all of these things apply. And this is where, a lot of businesses are not able to take full advantage of what they have at their disposal. It's amazing, but like I said, a lot of people want to try to cheat their way through and try to get what they can, but there is so much more that comes along with just reaching out, saying, "Hey, this is what I would like to do. I hear you say this, I hear you say that," and pay your way as well. But most people want an information grab, and then it really doesn't work out, which is really a sorry ass way to do it. If you got somebody that know what they're doing, that's been through the process, that's giving you all the game that nobody else is going to give you, then for you not to deal with that individual, it just says what your intent and your motive is, and that you're trying to cheat, and you're not gonna make it very far anyway. So if you're tuning in, I got Cash App scrolling across the screen. You can always hit that. Um, all of that, because again, the information is fire. You're not gonna get no fire information like this from nobody you talk to. Just pay attention and tune in. All right, so entities can adopt any decision-making processes they prefer. Entities with small numbers of investors typically choose what's called the single tier process, in which the investors make all the decisions. Now, you do have a lot of larger entities with larger numbers of investors. Typically, they choose what's called the two-tier process, in which the decision-making authority is shared between the investors and the managers, those that they hire to run the company. And it's kind of like the managers want to make a decision, but they got to run it by the investors, and and it has to get approved on both levels, type of thing. But decision making is shared in two ways. In the first, the investors retain the right to make fundamental decisions, but they delegate it to the managers, who usually include some but not all of the investors. The exclusive right to make ordinary course decisions. And so you remember that ordinary course, that's another one of those terms. If you watch my previous videos, then you know I talk about the corporate speak or paying attention to certain terminology, things that you need to remember. I always advise if you're watching any of my videos, if you could turn the captions on. That way, as you're listening to the video, you can look at the words in the screen and it can help your memory process it better because you'll need this. And again, the game I'm giving, see, we running these companies the right way. 80 to 90% of people that have their LLCs set up, they're not even managing them right. They're not even running them. They're just leaving them in the default status just to say they got an LLC. They just want to be in with the cool crowd and they don't know shit about what they're doing. You know what I mean? And I'm not trying to beat nobody up. I'm just trying to give you the game so you can hone in, so you can pay attention, and also know that you cannot cheat your way. There's a lot of people that got LLCs right now. It's a lot of people making a shitload of money. It's a lot of business owners out there. Y'all making good bread. But guess what? Y'all, you're taking your deductions. You're trying to find a single way to save costs. When if you just activate your LLC, manage it the right way, then your taxes automatically probably going to be cut in half. The tax advantages are there. They're on a whole nother level. And then not only that, you get the right guidance, the right coaching, and you're able to build your business the right way. You're able to build your business's credit the right way, and you have relationships with whoever your vendors are. Corporations do business with corporations. Corporations lend other corporations credit, net 30 terms, net 60, net 90. You can build your business credit up. And what one of the best ways to free up your cash flow so you can put that money into other areas of the business than, let's say you own a restaurant. And let's say you go get your account with Cisco Foods and you start doing business with Cisco Foods. Shout out to Cisco Foods. You do business with them, right? And you do enough business with them over time where you can open up an account with them. You open up a credit account with them. They extend you credit. You've already been building and working on your credit on one of the lower tiers by, dealing with companies like Uline. That's just one example. Or it's several more. I just threw that one out there, but they typically give new businesses credit net 30 accounts without really being established. But after you've done that for a while, then you may be able to open up an account with let's say back to the Cisco Foods example. And then what better way to get all of the products that you're using on credit, right? You actively making money every day, so you flipping it, and then boom, you just paying your bill. Now you got this extra money that you was shelling out, going to Sam's, going to other wholesale places, buying all this stuff, cash or whatever way you was paying for it, versus the opposite way. And you're using, then not only that, but you're building up your company, you're building up your company's credibility throughout the corporate world. You know what I mean? So it's a difference, and then not only that, none of this is tied to your personal credit. Your limited liability is there. And it's just beautiful. But I got a little off track. But I'm gonna do that throughout these conversations and these lives, so y'all can really, really pick up and hone in on what I'm saying. You have to activate your LLC. Most of y'all don't know. You think you know, you say you know, you just went and got that thing just because everybody else was going to go get it. And then you may have looked into it seriously. You may have talked to a CPA about it or ran it by an attorney, but they steered you wrong, because if they didn't tell you to set it up and run it and manage it as a C corporation, then they steered you wrong. You know, they try to tell people that, oh, it's for companies companies that's making a ton of money, or you got to have XYZ amount in revenue, or it'll be more advantageous for you tax wise if you just manage it as a S corporation, or leave it in its default status where it's a disregarded entity, and whatever money that the LLC makes, it passes through to you, and you just pay it on your 1040, and I can get you all of these deductions, and yeah, that's best for you because of the amount of money that you're making. But they tell you all of those things, right? But then they also don't tell you that, well, you really don't have no limited liability because everything is running through you. You're paying it on your taxes. And what's the really limited liability, guys? How can they'll sell that to you and tell you that you will still have limited liability, but make it make sense. What's limited liability? Limited liability means that you're not responsible, right? Right. But if you put your social on everything, because you're operating it as a sole proprietor, even though they tell you, okay, put your EIN, but you're always still plugging in your social. They're going to always make you do a personal guarantee in most of these cases, right? So, I mean, what do you really, really have? It's just a sole proprietorship. So, and then not only that, you can't sell it, you can't pass it down to your kids, you can't do any of those things. Why? Because it's worthless, because you're not building up anything under that EIN, solely under that EIN. Basically, a LLC in its default status is nothing but a sole prop. If your business is not paying its own taxes, then you out of the loop. Everything that if your LLC is not paying its own taxes, then you're out of the loop. The only thing that you're doing is you just got a fancy name. That's it. You ain't got nothing. And that ain't I ain't trying to ruffle no feathers. I'm not trying to do any of that. I'm just telling you the truth. So you need to activate your shit. You do. And then not only do you need to activate it, not just for the sake of saying I got this, because along with that comes certain responsibilities. There's certain ways you have to do things, certain types of emails you have to have or that you need to have, dedicated business addresses, phone numbers, lengths of time you need to have these things. And it's a whole different way of doing it than just if you were doing it yourself under your name. You know what I mean? Or under a company's name where you were um, signing off on everything. See, the corporate way, the way once you activate your LLC, or even if you form a C corporation, everything is solely in the company's name. Nothing is in your name. Nothing. If anything is in your name, then you risk piercing your corporate veil. And we'll talk about that later on. I'm going to talk about that later on throughout one of the assignments slash chapters. But you'll pierce your corporate veil. You have to keep everything totally separate from you. That's why you can't do any personal guarantees. You can't. You have to take the necessary time to build your baby up to where it's going to be able to do it all on its own. And it's feasible. See, a lot of people say, okay, well, only way you're going to be able to get it is if, you sign the personal guarantee and then, no, you don't do that. You just take the necessary time to build up your, if anything, you finance you can get capital from your invoices. That's a better way than putting a personal guarantee on something. And then you could build your credibility up that way because you don't want to put your name on nothing. You don't want to, not if you're setting your company up way, not if you are operating your company totally separate from you. All right, let me get back on track. This is why I be taking a little longer because I be jumping off course a lot, but it's necessary. All right. So we talked about the way decision making is shared. Investors retain the right to make the fundamental decisions. All right, and last we were on ordinary course decisions, which relate to day-to-day operations or activities, such as what products to sell, how to price them, and whom to employ. Okay. Damn, boom, boom. All right, and so the second way managers and investors share decision making is for the managers to make a fundamental decision and then submit it to the investors for their approval. Only fundamental decisions approved at both levels become effective. All right, and so at either tier of a two-tier process, the decision maker may be like an individual, one person, or it could be a group. All right, you remember I told you guys one person can run the whole shebang. Don't let them fool you. They'll tell you that. You can go, man. These people will make. Oh, ask these attorneys. You can call an attorney right now. Call a CPA right now, and tell them that you want to set up your LLC to be ran as a C corporation and watch what they tell you. I bet you they won't do it. I bet you, man. That's a. I bet that's a good bet. 80 to 90%. And it's depending on what you're willing to pay. They're gonna bust your head. And if you really want to pay for it, if you're like, man, come on, I know you could do it, then they're gonna bust your head. You mean you'll pay for it. But man, it's a good high percentage of them that's just gonna tell you that no, that's not, that that's not for you. Period. And they do have a duty. These people, they have a duty, and when they certify and they become professionals and they take the little boards and the examinations and the attorneys pass the bar and the CPAs do their little thing with the examinations and the board and all of those different things, they have certain standards that they have to uphold. They have a responsibility, just like the fiduciary duty that you have by managing a C corporation. It's the same thing. You have a fiduciary duty. You can't just go running nilly willy thinking that, oh shit, like Kev say, oh shit, and you got all this going on, and ooh shit, like it'll turn into like a kid in a candy store, but you can't. You have to be poised. You have to be responsible. But we're gonna get into that here in a minute. All right, let me go ahead so we can get to that. All right, so at either tier of a two-tier process, the decision maker could be an individual or a group. Groups usually have the option to make decisions by voting or by written consent. Votes occur at meetings held pursuant to notice. An officer prepares minutes during or immediately following the meeting. Written consents are documents indicating an investor's or manager's support for some action signed and delivered to the entity. In most processes, written consents must be unanimous, but the default rule for shareholder decision making in Delaware corporations require only that holders of an absolute majority of the shares consent. An absolute majority is more than half of all shares eligible to vote. And again, one individual can also hold that meeting and make all those decisions. And if you're just an individual and you get yourself set up this way, just make sure, and you're not required by law, but keep meetings, hold meetings with yourself. You have to, create resolutions. See, there's so many things that are involved with doing this thing, but the advantages are well worth and well outweigh any of the processes that you have to go through, and they're not difficult. It's really everything that you're doing with your business anyway. You just have to do it in another way. It's just kind of like in another language. You're doing the same thing. Processes may be a bit different, but it's gravy though. But you need the right guidance. That's why I say you're not gonna be able to cheat. That's why I wrestled with this for a long time. How do I sit down and give out this information, knowing motherfuckers gonna information grab and want to cheat? And it took me a minute, and then I thought about it. I said, okay, well, if they want to do that, if they want to cheat, if they want to go try to take the shortcut, then they still gonna get stuck, and then it's gonna be a double fucking. You know what I mean? So to each his own. But all right. So among investors, voting is typically per share, per contribution, or per person. To illustrate, all right. So if an investor named Alice owns a 60% share and investors Beth and Chuck each own 20% shares, Alice will have control if voting is by shares, but Beth and Chuck will have control if voting is by person. So voting among managers is nearly always by person. All right, there's a thing called straight voting. Straight voting is the system most commonly used to elect managers. All right, this is this is if you have multiple investors, all right? You have multiple members, all right? So straight voting is a system most commonly used to elect managers. The first step is to determine the number of votes the investor has. That is usually the number of shares the investor holds. All right, and let me stop. I just had a thought. So also a lot of people that want to run corporations may want to have a C corporation, and all of the stringent requirements that the state has. Now, the state has very stringent requirements when you go set up a C corporation, but those requirements are very relaxed if you set your company up as an LLC, but you manage it as a C corporation. They're the same thing basically, but there are rules that you must abide by if you form a C corporation outright. Okay, I just kind of wanted to throw that out there. Also, I just want everyone to know, I just want to say that this video and the things that I'm reading and explaining and going over are definitely for educational purposes. I don't like to use the word entertainment. Some of that stuff says, oh, it's for entertainment purposes, but this is solely for educational purposes. I highly recommend that you consult with someone that has thorough knowledge of the processes. Do your due diligence. Find people that are going to shoot it straight to you. You know, hint, hint. But um, all right, so we were talking about straight voting, and the first step is to determine the number of votes the investor has. That is usually the number of shares the investor holds. The second step is to determine the number of managers to be elected. Each investor may cast the number of votes it has for each one or more candidates, up to the number of managers to be elected. For example, if an investor owns 100 shares, each share has one vote, and five directors are to be elected. The investor may cast 100 votes for each of five persons. Cumulative voting. All right. Cumulative voting is the same as straight voting, except that the investor may accumulate its total votes by casting all of them for the same person or divide them among any number of persons. On the facts of the example, the investor could cast 500 votes for one person or 250 for each two people. All right. So if an entity has issued two or more classes of shares, provisions in the fundamental documents will determine whether both classes vote in the same elections to elect all of the managers, or each class votes in a separate election to elect one or more of the managers. The latter is referred to as class voting. For example, an LLC might issue Class A interests entitled to elect three managers and Class B interests entitled to elect four managers. The holders of the Class A interests would elect their three managers in one election. The holders of the Class B interests would elect their four managers in a separate election. The election in each class might be by straight voting or cumulative voting. The default rule in corporations is that shareholders elect all the directors annually. The most common alternative is a classified board or a staggered board, to which some but not all of the directors are elected annually for multi year terms. For example, a corporation with a 9-member board might divide the 9 seats into three classes and elect three directors to 3 year terms in the first year, three directors to 3 year terms in the second year, and three directors to 3 year terms in the third year. You have all of this flexibility, all right? The default rule in LLCs, and when they say default rule, they mean the rules that the statutes provide. You have the authority to determine how all of this goes in your operating agreement or in your articles of organization. All right, that is your job. If you don't put it there and have it your way, then you have to abide by the statutes. All right. So the default rule in LLCs is that no schedule for electing managers exists. LLC managers may be chosen or removed at any time by the alternative vote or consent of a majority of the members. The default rules for limited partnerships provide no mechanism for limited partners to remove general partners. All right, on to this last part. I think I'll do entity finance tomorrow. All right, so we're going to talk about the fiduciary duties. Okay, the fiduciary duties. We're going to talk about those. All right. Managers have fiduciary duties of care, loyalty, and good faith. All right. These are really important when you're setting these companies up. Um, when you're setting them up and when you managing them in this manner, you have a duty because you can easily, misconstrue shit. You can be like, oh shit, I can go do this now. I can go do that. I can go get that living room suit I've been wanting. I'll just put it back. You can't do that, Jack, at all. You can't because again, that is like a violation. You can't cheat your way even through that because if you do, it will catch up with you, and if it catch up with you, then um, it just depends. It really does. It really just depends. But we're going to talk about fiduciary duties. All right. The managers have fiduciary duties of care, loyalty, and good faith. These duties are pervasive. As the court sometimes put it, every action is twice tested. To be valid, the action must satisfy both tests. The first test is whether managers have acted in accord with the applicable entity statute. The second is whether they have acted in accord with their fiduciary duties. Most investor litigation is for alleged breaches of fiduciary duties. All right. And again, if you got your LLC activated, like I like to call it, magically activated, then you have fiduciary duties. And these things apply to you. All right. So I'm gonna touch on investor litigation. Um, that's something that I'll touch on there briefly. Entities are entitled to sue managers or controlling shareholders who breach their fiduciary duties. If the entity's manager have conflicts of interest with respect to filing the lawsuits, perhaps it's because they would be the defendants. Any investor can bring the lawsuit on the entity's behalf in the form of a derivative action. This is terminology that you need to pay attention to. Turn your captions on. As you're turning your captions on and you're listening, you're watching the words go down the screen. It'll help your brain process it a lot better. So when you hear it again, you'll be able to say, okay, so this is how that's just one of the ways that we can soak up information. So, what's a derivative action? A derivative action is a lawsuit brought by an investor against the entity to compel the entity to sue a third party. And so, as mentioned in the previous videos preceding this one, um, we talk about how the entity itself can do many of the same things that a natural person can do. Most of the things they can sue, they can be sued, they can own property, they can own other entities, they can own cars, they can, they have their own credit, all solely in the entity's name. That's what an entity is. It's something that's totally separate from your business. As a matter of fact, the entity owns your business. You own shares in the entity. So you control the entity. Remember what Warren Buffett said: own nothing, control everything. And that's that whole setup. And it get real deep. Layers on top of layers on top of layers. But and this is a good manual I got. I like when the pages do this. It's gonna cover all that. So stick with me. We got a lot to go. I don't know. We may get through this whole deal and probably it's gonna be a lot of videos. I'm willing to say about 6 months, but it's gonna be a lot of content for you to go back over. And the content is just it continues. It goes and goes and goes. So and it all builds up on the previous. So just keep going, keep following the videos, pay attention. All right, so we were talking about a derivative action, and the third party is usually a current or former manager, and the action is usually for breach of the manager's fiduciary duties. The lawyers who bring successful investor litigation are entitled to recover their fees from the settlement or award. Specialized plaintiffs' attorneys actively monitor the affairs of the companies whose shares are publicly traded and bring the actions. The same attorneys also bring class actions on behalf of investors when managers or controlling shareholders wrongful acts directly injure investors. And this is another thing. When you magically activate your LLC and you set it up in this manner, um, there's really no limit to the things that you can do and to the ways that you can set your company up. You can do an IPO, you can do an initial public offering. This is basically what the concept of a startup is. Startups, they get seed money, meaning that they have people invest in their idea. Then they come together, they form everything, form the board, form the company, set out all the rules in the articles of organization or the operating agreement, and then boom, they go for what they know. They have all their people in place. They've got all these investors already, and it's a process, and this is a process that we need to learn. This is how they're moving. This is how they're making big deals. This is how one of the ways that we win. All right, one of the ways that we win. So let's keep going. All right. So, a class action is a lawsuit in which one or more representatives of a class of injured persons sues on behalf of all members of the class. And I know most are already familiar with class actions as they operate in other areas of the law. You know what I mean? Some of those examples are what? The pharmaceutical industry has a lot of class action lawsuits. The trucking industry has a lot of class action lawsuits. The automobile industry has a lot of class action lawsuits. So we already know what a class action lawsuit is. All right, so we're going to talk about the duty of care. A manager's duty of care is similar to the general duty of care imposed by tort law. The manager is required to conduct him or herself in the manner that persons in a like position would reasonably believe appropriate under similar circumstances. But in the investor litigation context, the duty of care is limited in ways that are almost entirely eviscerated. All right. So first, for most entity types, the duty of care is only a duty to inform oneself of the information necessary to make a decision before making it. In fulfilling even that narrow duty, the manager is protected by rules that entitle the manager to rely on information furnished by managers, lawyers, financial advisors, and their experts. All right. And in a partnership, LLC, or limited partnership, the fundamental documents can alter the duty of care in any manner that is not, quote, manifestly unreasonable, close quote. In a corporation, the articles of incorporation can exculpate managers from the duty of care entirely. Exculpation is forgiveness in advance for any violation managers may commit. Alteration and exculpation are common, with the result that the duty of care no longer has much effort in investor litigation. And so, again, this is where a lot of your limited liability comes in at. It does protect you, it does protect the managers from a lot of things, as you just heard. All right, so the duty of loyalty. The duty of loyalty is a duty to act in what the manager believes to be the best interest of the entity, not the manager, not the sales guy, not the supervisor, but in the best interest of the entity. Among other things, the duty requires managers to disclose their conflicts of interest. A manager who breaches the duty of loyalty is liable for damages, forfeits all right to compensation during the period of misbehavior, and must surrender conflict tainted profits to the entity. All right, so you keep all of these things in mind, especially for those that are forming companies with other people. All of these laws apply. You may get a partner that you think is good. Y'all may start out Gucci, everything going well, and then before you know it, he's doing some questionable things. He making side deals with the salespeople. He giving, major deals to people that's maybe kicking him back under the table. All of these things are totally against the best interest of the entity, and it can bring you down. See, when you cross over and when you magically activate your LLC, now your LLC is a C corporation. And so managing your LLC as a C corporation is totally different from managing it as a sole proprietor. So you have rules. There are laws that govern these entities, and by law, you can dictate in detail how your company is managed. Law applies as well. But your fundamental document trumps the law. Okay, so that means that what your fundamental document says is what goes. All right, so the next duty is the duty of good faith. All right, so let me see. I need to finish the duty of loyalty. A manager who breaches the duty of loyalty is liable for damages. All right, I said all of that. So next is the duty of good faith. And the duty of good faith is a wild card. This defined, it's real vague. So it requires honesty, sincerity, candor, decency, fidelity to office, adherence to generally accepted corporate norms. And just to be solid, it requires the manager to not knowingly cause the entity to violate the law. You know what I mean? So there are so many. It's like so many things that you can do where, like, if you have ulterior motives, or if you're dishonest in any way, there are opportunities that you can take and you can do things. But what if you get caught? You know what I mean? Not only that, you putting yourself at risk, but you're putting the reputation of the company at risk. It's a lot of those things that you're putting at risk, and they got something for that ass too. Especially when you start doing it on a macro level, which is where we need to go. Which is all of this. What all of this is designed for. This is designed for doing big things. All right. So the next thing I want to talk about is conflicted decision making. And managers who have conflicts of interest with respect to a decision, or who are under the control of someone who does, are not considered qualified to make the decision. It's simple as that. All right. Any type of conflict of interest with, making major decisions, don't do it. You know what I mean? And then if you tied into somebody that has conflict of interest, don't be involved. Okay, that a manager was chosen for the job by investors or other managers who are not qualified with respect to the decision does not itself render the manager unqualified. That link is dismissed as mere structural bias, another term. All right. So if managers who are not qualified make a decision anyway, the decision may be invalidated on that basis unless it is ratified by the shareholders or approved by a judge as fair to the entity. All right. And very last, controlling investors' fiduciary duties. Investors who neither control the entity nor act in the capacity of managers are entitled to act and to vote in their own self interest. That is true even if their interests are in conflict with the interests of the entity or the other investors. Investors who control an entity, however, all right, they have a fiduciary duty to act and vote in the entity's interest. All right, for example, an owner of shares with the majority of the voting power in a corporation has a fiduciary duty to the corporation and its shareholders to vote the shares only in favor of transactions that are fair to the corporation. All right, in some jurisdictions, the majority shareholders' fiduciary duties include fixing fairness to the minority, meaning those who own less amount of shares than those who own majority shares. All right. But in most, the majority are free to favor their own interests over the minorities, provided the favoritism does not harm the entity. And such favoritism, if extreme, is referred to as a freeze out. If again, another term. Those jurisdictions, investors are expected to contract for protection against freeze outs at the time they invest. So all of this is pertinent to the direction and to the road that we need to head down. None of this is going to change anytime soon, no time soon. These laws and these statutes have been in effect, and these are the things that we lack. And these are the pieces of information and the information that we need to know. We need to know how to manage our companies in a legal, lawful way. All of that, oh, I'm just going to go get me a LLC because everybody else getting it, and then you don't know what to do with it. Somebody jump on here and jump on my live and jump in my comments and tell me that you know. Tell me that you know about these things that I'm saying because we got a whole lot more to go. Then I can invite you up on the platform and we could both go through it together because I could use somebody else that's willing to get up here and deliver this information as well. Trust me. Trust me. So, any comments, any questions, anything like that, put it down in the comments. Reach out to me, man. Inbox me, text me, call me. My number all over the place. Inboxes, however it go. Um, and we could do the thing, man. We can Zoom. We can get together here on StreamYard. There are many things that we could do to be able to bring this together and talk about some things. But tomorrow, I'm gonna touch on entity finance and do some other things, investment, being able to transfer your investments and all of that. But we got a long way to go. A long way to go, and a whole gang of good, solid, legal, lawful information. We need it. We need to distribute it. We need to share the video. We need to like, subscribe, follow, all of those actions that you take on the respectful platform. What YouTube, you subscribe, Facebook, you follow, I think Instagram, you follow, whatever, however it go. Do all of that stuff for me. Share the video. If you got any people you know that's got LLCs, share the video. Tell them to go subscribe so they can get into these videos and that they can watch it and they can get these nuggets that I'm dropping. Tell them they could also shoot some to their Cash App. You ain't got to be shy at all. You can do that because these some nuggets, man. These nuggets that the people not even telling you. Your coach is probably not even telling you. All of these things they're not gonna tell you, and we're gonna get down to the real nitty gritty on a whole lot of stuff, man. I mean, it's. Let me see what some of these chapters are. Entities, limited liability, entity finance, investor decision making, manager decision making. Um, I mean, just so much more like in depth on the legal aspects of doing these things and all of the things that you can do that you can't do. Um, this is gonna be amazing, amazing information and stuff that we need to know. But that's it for tonight. Um, click like, share, subscribe, all that stuff. You can even hit the Cash App. Listen, man, all of that because all of it is time consuming, researching, studying, all of that. No, you're not paying for the information. You're investing in your future. You know what I mean? And more so than a Cash App, you need to be calling to set up some type of something for you, especially if you're going in that direction, because that's going to be the best thing for you. All of the information is good, but you also need to know what to do with the information, how to do it, when to do it, and all of those things. But other than that, I'm out. I keep using this avatar because um I be explaining this. I explained it in them other videos. And I be having these glasses on, and I be having a squint, and I be out in the screen. So I be want to be comfortable. I don't be want to have to worry about, all of that. So the avatar is good, and it really look like me too, dude. Look like me. I kind of tweaked him a little bit to make him kind of look like me, but my eyes ain't that light. But the face shape and all that, It's crazy. But I'm for the end this broadcast, man. Y'all have a good night. Enjoy your weekend. Enjoy your Saturday. Um, they got an old holiday coming up, but I don't be rocking with them holidays because they all have meanings that we really don't be ready to discuss. That's just on some other level stuff. But I'm out, man. Y'all have a good night. Enjoy yourself. Peace, love, happiness. Learn some shit.